Welcome to Motivation at Hand, Ma. To know is to know how. Part 9. Case 123-CR00257 TSC Document 139 filed November 6, 2023, in the United States District Court for the District of Columbia, United States of America versus Donald J. Trump, defendant. Government's omnibus opposition to defendant's motions to dismiss the indictment on statutory and constitutional grounds. The fair notice doctrine does not provide a basis for dismissal. The defendant contends electric case filing, ECF, number 113 at 25-31, that the indictment should be dismissed for violation of the fair notice requirement of the Due Process Clause. In doing so, he asserts that there is a long history in our nation of presidential elections involving facts purportedly similar to the 2020 presidential election, specifically invoking, same as at 25, the elections of 1800, 1824, 1876, 1960, 2000, 2004, and 2016. He then asserts same as that his conduct was fully consistent with and inspired by those examples, adding that because none of those events resulted in criminal prosecutions it would violate his due process rights to convict him here. The defendant's fraudulent and corrupt conduct as charged in the indictment stands in sharp contrast with the historical examples he cites, and neither history nor law provide a basis to dismiss the charges on fair notice grounds. The umbrella term fair notice, also sometimes called fair warning, is embodied in three related manifestations. 1. The vagueness doctrine. 2. The rule of lenity. Footnote 15, the rule of lenity has no application here, see supra, above page 16, and the defendant advances no separate lenity challenge as part of his fair notice claim. And 3. The rule that when a court applies a novel construction of a criminal statute to conduct that neither the statute nor any prior judicial decision has fairly disclosed to be within its scope, that novel construction may not be applied retroactively. United States v. Lanier, 520 U.S. 259, 266, 1997. In each of these guises, the touchstone is whether the statute, either standing alone or as construed, made it reasonably clear at the relevant time that the defendant's conduct was criminal. Same as at 267. None of these manifestations of fair notice undermines the charges in the indictment. A. The defendant had fair notice that the charged conduct was unlawful. Although the defendant briefly gestures at vagueness concerns, ECF number 113 at 26-27. He does not actually contend that any of the statutes charged here are void for vagueness. Nor could he. C. Concord Management and Consulting LLC, 347 F Supplement 3rd at 59-60. Courts have repeatedly rejected vagueness challenges to Section 371. As applied to conspiracies, like this one, to impair lawful government functions, United States v. McHugh, 583 F Supplement 3rd 1, 20-21, DDC 2022. Rejecting various vagueness challenges to Section 1512C, 2, United States v. Price, 383 U.S. 787, 806 No. 20, 1966. This court has rejected the argument that the constitutionality of Section 241 may be affected by undue vagueness of coverage. Moreover, nothing in this case implicates the manifestation of fair notice that bars retroactive application of a novel judicial construction of a statute. The defendant suggests, ECF number 113 at 25-27, that if the court were to find that the conduct alleged in the indictment fits within the charged offenses, such a finding would be tantamount to an unforeseeable and retroactive judicial expansion of statutory language that appears narrow and precise on its face. Rogers v. Tennessee, 532 U.S. 451, 457, 2001. Analogous to the prosecutions at issue in Bowie v. City of Columbia, 378 U.S. 347, 354, 1964. There, South Carolina courts had upheld the convictions of civil rights demonstrators engaged in lunch counter sit-ins, who were found guilty of criminal trespass under a statute that on its face and throughout nearly a century of judicial interpretation. Applied only to those who illegally entered land after receiving notice of prohibition from the owner, and that due process precluded it from having retroactive effect. Same as at 354, see Rogers, 532 U.S. at 457. The Supreme Court reversed, explaining that the state court's expansion of the statute was so unexpected and indefensible by reference to the law which had been expressed prior to the conduct in issue. That principle has no bearing on this case. Nothing about the face of the charged statutes or their prior judicial construction suggests that the defendant's conduct fell outside their scope. To the contrary, the statutes plainly prohibit conspiring to defeat a government function through deceit, trickery, or dishonest means, see Glasser, 315 U.S. at 66. Conspiring and attempting to corruptly obstruct an official proceeding, see 18 U.S.C. section 1512 c. 2. And conspiring to violate the right of voters to have their votes lawfully counted, see Classic, 313 U.S. at 314. And the conduct alleged in the indictment here falls within the plain language of the charged offenses, see Supra, above pages 4 to 17, count 1, pages 17 to 22. Simply applying the facts alleged in the indictment to the well-established statutory elements would not require any sort of novel judicial construction. Pages 17 to 22, counts 2 and 3, pages 22 to 25, count 4. Much less one that would be unexpected and indefensible by reference to the law which had been expressed prior to the conduct in issue. Rogers, 532 U.S. at 457, quoting Bowie, 378 U.S. at 354. Rather, each of the statutes, either standing alone or as construed, made it reasonably clear at the relevant time that the defendant's conduct was criminal. Lanier, 520 U.S. at 267. The defendant's more targeted attack, ECF number 114 at 28 to 31, on section 241 fares no better. He relies principally on Lanier but misapplies the test for fair notice set out in that case. The defendant in Lanier was convicted under 18 U.S.C. section 242, which criminalizes violations of constitutional rights under color of law, for sexually assaulting 5 women while serving as a state judge. 520 U.S. at 261. The Court of Appeals vacated the conviction on the ground that the defendant lacked fair notice that his conduct violated a constitutional right because no Supreme Court decision with fundamentally similar facts existed. Same as the Supreme Court reversed, concluding both that fair notice could be provided by decisions from all federal courts, and that the proper fair notice inquiry asked whether the contours of the right violated are sufficiently clear that a reasonable official would understand that what he is doing violates that right. Same as at 268 to 70. Under Lanier, therefore, a defendant needs to have fair notice that the constitutional right exists, not that the precise conduct he pursues violates that right. Prior cases readily supply such fair notice here. Following Lanier, courts confronted with fair notice challenges in Section 241 cases involving voting rights have reviewed prior court decisions not in a search of a fact pattern that matches what the defendant is alleged to have done, but instead to assess whether the right is sufficiently defined such that the defendant has fair notice that interfering with the right falls within the statute. See United States v. Mackey, F. Supplement 3rd, 2023 WL 363595, at 11 EDNY January 23, 2023. Providing extensive analysis of Section 241 notice challenge to a charge of interfering with a presidential election and finding that Section 241's fair warning doctrine focuses most centrally on the right that has been violated. In this case, the right to vote, United States v. Tobin, number 04 CR 216, 2005 WL 3199672, at 2 DNH November 30, 2005. Although the defendant quotes only a portion of the relevant language, he acknowledges, as he must, that voting in a presidential election is a fundamental right under the Constitution. ECF number 114 at 29, citing Bush, 531 U.S. at 104. See also Classic, 313 U.S. at 314, when state makes primary and integral part of the procedure for the popular choice of congressmen, it becomes a right established and guaranteed by the Constitution. The states have chosen statewide election as the means to select their presidential electors, and therefore the Constitution protects the right to vote in a presidential election, both directly and under the Equal Protection Clause of the 14th Amendment, including as incorporated into the Due Process Clause of the 5th Amendment. Bowling v. Sharp, 347 U.S. 497, 498, 1954. Section 241 prohibits conspiracies to injure that uncontested right. Moreover, a long line of prosecutions for interfering with voting rights provided fair notice to the defendant that his conduct, as alleged in the indictment, falls squarely within the heartland of that statute. Footnote 16, while the defendant concedes that the right to vote is clearly established, he describes, ECF number 114 at 29. His conduct as contesting an election through lawful means, including by public statements, court challenges, or alternate slates of electors. That description mischaracterizes the indictment. The indictment alleges various ways that the defendant and his co-conspirators sought, through fraud and deceit, to violate the rights of voters by setting aside the legitimate outcome of the state's election and discarding legitimate voter and electoral ballots. As set forth in detail in Mackey, 2023 WL 363595, at 11-14, for over a century Section 241 cases have involved efforts to suppress legitimate ballots or change the outcome of elections. See United States v. Mosley, 238 U.S. 383, 385, 1915. Election Board officials charged with conspiring to discard legitimate ballots. United States v. Plava, 66 F. 2nd 529, 530, 2nd circa 1933. Board of Elections inspectors charged with falsely tabulating ballots to favor certain candidates. Convictions reversed on separate jury grounds. Classic, 313 U.S. at 321. A conspiracy to prevent the citizen from voting or to prevent the official count of his ballot when cast. Is a conspiracy to injure and oppress the citizen in the free exercise of a right secured by the Constitution within the meaning of the predecessor statute to Section 241, United States v. Saylor, 322 U.S. 385, 386, 1944. Election officers charged with interfering with ballots. United States v. Skurla, 126 F. Supplement 713, 715, WD Pennsylvania 1954. Defendants charged with various acts of interference with ballots. United States v. Townsley, 843 F. 2nd 1070, 1073-75, 8th circa 1988, scheme to discard certain absentee ballots. These cases, as well as other voting rights prosecutions, demonstrate that while interference with voting rights can take any number of forms, it is well established that acts to interfere with ballots or to attempt to alter vote outcomes through fraud and deceit fall squarely within Section 241, providing the defendant with fair notice. The defendant's misplaced reliance on United States v. Bathgate, 246 U.S. 220, 1918, and United States v. Bradbury, 517 F2 RD 498, 7th circa 1975, does not undercut this conclusion. As explained in Mackey, 2023 WL 363595, at 12 and number 10. Bathgate held that Section 241 did not extend to bribing voters, because Congress had repealed a nearby statutory provision that addressed bribery and protected only the personal right to vote, which the voters in Bathgate had exercised 246 U.S. at 226-27. But the relevant part of Bathgate was abrogated by Saylor, 322 U.S. at 389, and Bradbury is likewise an apposite, as it held not that there was a problem with the charge in the case, but rather with the proof at trial. While the government charged a conspiracy to interfere in a federal election, It proved only vote fraud in a state and local election 517 F. 2nd at 500. The offense charged in the indictment was not proved. In sum, the defendant had fair notice that his conduct, as alleged in the indictment, was a violation of Section 241. Part 10. To be continued. B. The defendant's historical examples do not raise fair notice concerns. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.